morning. These chairs are heavy. Please be seated. Very good. The court will now call cause number 0425-351 CV, City of San Antonio et al. Versus Martin et al. Announcements, please.
Jackie Stroh for the appellants. Ready, Robert?
Good morning.
Maha Gayas for appellees.
Good morning.
Good morning.
Council's been apprised of time limitations, so you may proceed, Council, when ready.
May it please the court. My name is Jackie Stroh, and I represent the appellants, the City of San Antonio, and officers Moynihan and Vidal. The main issues the court must decide today are whether the City of San Antonio retains its immunity from claims for declaratory and injunctive relief concerning the interpretation of a penal code provision, whether the city retains its immunity from a takings claim based on an interpretation of that same statute, and whether officers Vidal and Moynihan retain their immunity from claims of ultravirus, again resting on the same interpretation of that penal statute. The answer to all questions is yes. There were other claims that were raised in the trial court, claims against the officers in their individual capacity, claims against the SAPD, perhaps a tort claim against the city, but all of those were non-suited and dismissed by the trial court with prejudice. So we're only here today on the claims for declaratory and injunctive relief against the city, takings claim against the city, and ultravirus claim against the officers. Before turning to the issues on appeal, I just want to briefly talk about the court's appellate jurisdiction because it's something that was addressed by appellees in their brief. Their arguments, though, rested on two false premises. First, that the appellants invoked only Section 51.014A5 to assert this court's jurisdiction, and that A5 only permits the exercise of jurisdiction over issues of official immunity. Neither of those things is true. In our notice of appeal and in the brief of appellants, we invoked both A5 and A8, but it wouldn't matter anyway. Whatever we cited to, if the court has jurisdiction, it has jurisdiction. We went through a litany in our reply brief explaining why the court has jurisdiction over every single one of these issues. They concern standing, immunity, all of which implicate subject matter jurisdiction. Even the limitations issue is within this court's jurisdiction over this interlocutory appeal because it concerns a compliance with a condition precedent, and under Section 311.034 of the Texas Government Code, conditions precedent and compliance with them are jurisdictional in nature. So the court absolutely has jurisdiction over all issues in this interlocutory appeal. Turning to the issues and first discussing the declaratory and injunctive relief against the city. Before turning to the penal aspect of Section 47.014B, which is what we're, the crux of the plaintiff's claim, the Declaratory Judgments Act itself waives immunity as to a municipality only for claims that assert the invalidity of a municipal ordinance. We're not talking about a municipal ordinance here, we're talking about a state statute. The penal aspect of it just makes the plaintiff's burden unovercomable, I suppose. They are required to satisfy three elements if they want declaratory or injunctive relief from a civil court in the context of a penal statute. The first is they must be challenging the constitutionality of that penal provision. They must demonstrate imminent injury, and they must demonstrate that injury to vested property rights. In their responsive brief, they admit that they satisfy none of these. They're not claiming that the statute is unconstitutional. They simply want the court to interpret it the way they interpret it. They are not claiming imminent injury. In fact, they themselves admit they are facing no prosecutions. There are no raids since before suit was filed. They are not in the midst of any criminal proceedings, and this court held in Sterling anyway that the threat of prosecution is not an imminent injury to be solved in this way. Yes, sorry, go ahead.
It's okay. You brought up Sterling. Do you think it's dispositive in this case on that issue?
I do. It is. And it's also dispositive on the issue of what constitutes vested property rights. It says there's no right to use property in a particular way. There's no vested property interest in leasing 8-liners, which is what the plaintiffs were doing, at least in part. And it cites to an Amarillo Court of Appeals opinion saying there's no property interest in gambling paraphernalia. So they can't satisfy any of these 3 conditions. Now, their response is an odd one. What they say is, well, we don't have to satisfy those elements for declaratory and injunctive relief because we're not challenging the constitutionality and there is no imminent injury. That's a strange argument saying that they don't have to meet the elements because they cannot meet the elements. You cannot expand the trial court's jurisdiction by contracting your own claim and failing to satisfy the slim reed on which jurisdiction rests. So for all of those reasons, they cannot recover declaratory or injunctive relief against the city. Turning next to the takings claim, we've argued many bases for why their takings claim fails. The first, it concerns the public use element. We have cited a number of federal cases and state cases as well, including the Garcia case from this Court of Appeals, saying that when property is seized pursuant to a search warrant, it is not taken for public use. In fact, this court went further and said when property is forfeited, it is not taken for public use. There is also federal case law saying that once property is taken pursuant to a search warrant, whatever is done with it after that point cannot be for public use because it was taken pursuant to a search warrant. Mr. Martin testified in his deposition that he does not contest any aspect of the warrants as invalid and that no property was taken outside of the search warrants. So there's no question that there was no taking for public use.
So let me ask you a quick question.
Sure, go ahead.
If, Mr. Martin, if they present something to us or point to something in the clerk's record that talks about deals made between SAPD and forfeiture funds, and those funds being used in some public form or public use, what would be your response to that?
So even if there were forfeiture of any of the gambling machines or the proceeds or anything like that, which there's no evidence of that in the record, and those interlocal agreements talk only about the division of funds or proceeds after there has been some sort of forfeiture proceeding. So they don't apply in any event. But even if they did, this court's holding in Garcia is dispositive, where the court said monies obtained or property obtained through in-rim forfeiture proceedings are not taken for a public use. I mean, that's really the end of the argument. But they don't apply anyway because there's no evidence of any forfeiture proceedings. Regardless, the second point made by the city is that the plaintiffs cannot accomplish indirectly through a takings claim what they cannot accomplish directly through a declaratory judgment and injunction action.
Forgive my tardiness here. Go back to the first one. Are there other sister courts who held similarly to Garcia?
Yes, and I don't have the site in front of me, but yes, we did cite another Court of Appeals opinion that held that taking property pursuant to a search warrant is not a taking for public use.
Has there been any court who's at least mirrored the concerns addressed by Justice Willett in his dissent, arguing that there is potentially, especially in unique circumstances that may or may not apply here, where, you know, this kind of forfeiture might merit or fall under the definition of takings?
So I don't know if I'm familiar with Justice Willett's dissent that you're referring to, and I apologize, but I would say that
El Alivi State, where Justice Willett had dissented from a denial of review and expressed concerns about, you know, circumstances that might, again, echo the fact pattern that's contained in this record.
And I think the issue is that when the property is taken when it's seized pursuant to a search warrant. That's when you look at the public use element. Whatever use the city makes of it thereafter, if they sell it thereafter, we have federal case law cited in our brief saying that doesn't constitute a public use. I guess the point is that you can't retroactively imbue the original seizure with a public use element by virtue of what the city may do with it subsequently. I mean, it was seized pursuant to a search warrant. It was not seized for public use, whatever use the city may make of the funds in the future. So that would be our answer to that question. It's one that's supported by both this court's precedent, and it's one that's supported by federal precedent as well, interpreting the federal takings clause. Turning back to the point about using the takings claim indirectly to accomplish what they cannot do directly, we would just refer the court back to our arguments about why they can't recover declaratory and injunctive relief against the city, because the court does not, civil court does not have jurisdiction to construe a penal statute, whether they're specifically directly asking for a declaration or whether they're seeking a declaration under a takings claim. But even if the court believes that it can move to consider the takings claim in spite of no evidence of public use, move to construe Section 47.014B despite the fact that this is a civil court, the trial court's a civil court, and it's a penal statute, our interpretation of the statute is correct. Section 47.014B is an exception to the general illegality for 8-liner machines, but it's a very limited exception, and it requires payment for play in the form of non-cash novelty prizes. We have explained why the machines pay out in tickets, obviously, but exchangeable for silver, why silver is a cash equivalent, both under case law, which talks about silver as a cash equivalent, but beyond that, simply because under Hardy, which talks about what it means to be a cash equivalent, the readiness of exchange for cash, the ease with which one can exchange for cash, the readily marketable value of a thing. Those all apply to silver, especially under the facts of this case, where you have to an establishment. All of the establishments were located next to silver exchanges. To an establishment, all of the employees there referred the police officers who investigated the establishments to the silver exchange or to a pawn shop to exchange the silver for cash.
So,
yes.
You've said that there's no misinterpretation of the statute, or at least the city and your clients and are interpreting it correctly. However, these amusement facilities that contain 8-liners also have a city certificate of occupancy approved by the city. Correct? And it reads, and I'm reading from the plaintiff's petition, paragraph 27. It says the city of San Antonio, by issuing certificates of occupancy that clearly state quote, 8-liner amusement with no cash payout, close quote. So these amusement facilities are being allowed to operate, and then the city is coming in and interpreting the statute saying, no, these 8-liners are illegal. We're going to seize, we're going to raid, we're going to seize them.
Because the plaintiffs are making the representation to the city that they are operating legally. They are making the representation to the city that they are not paying out in cash or cash equivalents, and that's not true. When they apply for the certificate of occupancy, it's in the record. There's no investigation. They take the plaintiffs at their word and they issue the certificate of occupancy. Then they receive a citizen complaint that there's gambling going on. They're paying out in silver. There's a silver exchange next door. The officers go and investigate, and then they find that the plaintiff's representations are inaccurate. So the certificate of occupancy doesn't have any sort of res judicata effect or anything like that. There was no investigation at the time. They simply took the plaintiffs at their word, and the plaintiffs did not provide accurate information. Because in fact, the machines do ultimately pay out in silver, and silver is a cash equivalent, because under Hardy, it can immediately be exchanged for cash, even if those silver exchanges weren't right next door, and even if employees weren't directing. I mean, it's a complete runaround.
Yeah, but it's presumptive, is it not, though, when we'd have to presume that, again, what you just shared about illegal activity was outlined in presumably the affidavit in support of the warrant to seize, right? Presumably.
I'm sorry, say that, I'm sorry, I missed it.
All this about that it was performing an act that was illegal, right? All of those facts would be outlined, again, presumably, in the evidence that supported the warrant to seize, right?
The court doesn't have to presume anything. All of that's in the record.
No, I'm not saying that.
Okay.
What Justice Rios was sharing is that there was at least a presumption of legal activity when the ordinance was issued, right? The license, right?
Well, they took them at their word when they said they were, when they took them at their word when they said they were paying out.
When you certify, here, I'm going to give you a license, you perform some act of due diligence to confirm that what was represented was in fact in compliance with whatever was required to be submitted to effectively earn your certificate of occupancy, right?
Well, so it's not briefed, but they're
Saying that just, we cannot say, and we don't have to go down that trail, right, about what the city does in issuing these licenses. It's just the fact that a license has been issued, right?
that doesn't matter. I'm sorry, go ahead. Sorry.
That alone. And so the question then becomes, if that is, again, something to effectively say, the city has permitted me to engage in a certain activity or provide a service in my establishment, right? That's all fun and dandy. Everything else that followed would have been something that was the result of their investigation afterward, right? And presumably submitted before law enforcement, right, to go over there and get a warrant to seize, which actually it was part of the facts here as well. But if the contention still begins with the presumption that there was lawful activity, that I think is the presumption that needs to be made. And when they submit that evidence saying, here, we're conducting something lawful here, you gave us permission to do that. You certified us. You gave us a license to form. You permitted us to open our doors, right? I'm going through a totally down rabbit hole.
No, that's okay, because I do have an answer.
It's part of what their argument is.
But it goes nowhere because of this court's precedent. This court's precedent is very clear. It's not briefed because we didn't brief the issue of estoppel, which sounds like what you're arguing. I mean, not arguing, but asking about. I know, I'm sorry, I misstated. Asking about, I apologize. But this court's precedent is clear. For example, in terms of the City of Alamo Heights case, I can think of because I was involved in it. The court held there's no estoppel as to a city official. For example, if a city official says, yes, you can build, despite the fact that regulations, city ordinances prohibit it, and then somebody builds and they say, sorry, you have to tear it down.
I'm going to withdraw my questions because you're going off on an issue of estoppel and I'm not raising.
Oh, okay, I'm sorry. I'm misunderstanding then. I apologize. I apologize. But in any event, even if the court disagrees with our interpretation of Section 47014B, we have the final argument that the exception is unconstitutional. We cited two opinions from the Texas Attorney General, one in 1998, one in 2007. We cited the Fort Worth Court of Appeals decision in Riley. We cited the Supreme Court's case in Riley defining exactly what a lottery is. A game for consideration that involves chance and pays out a prize. This clearly qualifies. Martin testified as to all three elements, said this game is 100% based on chance. So it is an unconstitutional lottery, and the exception in 47.014B is unconstitutional. And because it's unconstitutional and because they acted pursuant to Texas penal law making the activities illegal, there can be no takings claim. Texas Supreme Court case law is clear that there is no taking when an official or city abates a public nuisance. Certainly criminal activity would qualify. Finally, with respect to the ultra-virus claim, I'll have to finish up on rebuttal. I just have a minute, but I'd like to get started. Only prospective relief is available, but the plaintiffs plead their ultra-virus claim, and it's tied up with the tort of tortious interference with past contracts. This court's case in Suarez is directly on point, Suarez versus Silvas, saying you cannot pursue an ultra-virus claim for past acts, even if you claim that they will happen again in the future, but have no evidence of any imminent occurrence. Regardless, the plaintiffs cannot recover prospective relief, declaratory or injunctive relief for the reasons that we've previously explained. We're talking about a penal statute here without a challenge to the constitutionality of the provision, without evidence of an imminent injury, and without evidence of injury to vested property rights. But ultimately, the plaintiffs get the ultra-virus claim wrong. They cite the Houston terminal case, which I'm sure they're going to talk about in their presentation, and which I'm out of time and I will address on rebuttal. Thank you so much.
If I may, you'll have an extra minute on rebuttal.
I'm sorry?
You'll have an extra minute on rebuttal.
Oh, no, that's okay.
You may need it. You never know if I'm here. Morning, counsel.
Good morning, Your Honors. May it please the court, my name is Maha Gaius, and I am here on behalf of Applees, Jimmy Martin, JML Games, and GGL Vendor Leasing. The issue before this court is whether government officials can repeatedly seize and destroy lawfully owned property and then still claim immunity as a matter of law. That answer is no, and this court should affirm the trial court. Texas law draws two bright lines. The first is that public officials shall not intentionally disregard the law, and the second is when the government takes or destroys property for public use, it must pay the owner. Here, there's evidence in the record that these officers knew that these machines were within the legal exception under the penal code. They raided Mr. Martin's businesses anyway, seized his cash, destroyed his machines, and continued to do so despite that knowledge.
The officers, though, were working with presumably valid search warrants
Yes, Your Honor.
that they would have taken to a magistrate to secure,
Yes.
and y'all never contested the search warrants.
Oh, that is not accurate. There is evidence in the record that motions to suppress were filed. They were granted. The findings of fact that we presented as a bench exhibit are from a search warrant that was suppressed. And those findings of fact, the criminal court found that the machines were within the exclusion, that the silver businesses that operated next door were independent entities that had no relationship with Mr. Martin's businesses.
You're talking about the findings of facts in the state of Texas versus Sylvia Gonzalez?
Yes, ma'am.
Okay, and
Yes,
how
Your
is
Honor.
that case related to Jimmy Martin?
Ms. Gonzalez, it's in the record, she was Mr. Martin's business partner, and they were operating that location together. And so she was arrested in the same raid that he was. He was also charged in that raid. And the attorney who represented her, I believe, also represented Mr. Martin in those convictions. But the conduct that those charges arise out of come from a raid that was conducted against one of Mr. Martin's businesses. And the
Same property, though?
same property, yes, Your Honor. Same machines, same business, and they arrested multiple criminal defendants. There's evidence in the record that these officers, over the course of these 10 raids, filed 41 charges, none of which were ever successful. The officers testified that they knew that the prosecutions were not successful, that Mr. Martin had approached them after the fourth raid to tell them that a criminal court had dismissed the charges, finding that the machines were lawfully owned.
Same machines.
Same machines. And despite that knowledge, the officers continued to raid Mr. Martin another 6 times, causing over $1 million worth of damages to his
So
businesses.
the property is not simply seized, it's actually destroyed?
The property, some property was seized and some property was destroyed. There's evidence in the
The
record.
warrant, forgive me, does the warrant authorize the destruction of property?
Your Honor, I am not certain of that. The warrant authorizes the officers to seize the motherboards from the machines, and in the process of seizing those motherboards, they destroyed the machines. Effectively, yes. And they also destroyed other property that was on site, including ATM machines. They seized all the cash that was on site, along with other property, which was within the...
Pursuant to the warrant?
Pursuant to the warrant and within the scope of the warrant. And the warrant shows an intent to take the property, but whether or not keeping the property was authorized under law, as the city stated, there's no evidence that any forfeiture proceedings were ever initiated. And here, and the city admits that the city kept the machines despite the fact that this was not gambling paraphernalia, as found by this court. It kept cash despite knowing that there was no illegal gambling activity occurring on site. And so that is why the city is not entitled to immunity from a takings claim. That is why these officers are not entitled to immunity. That is why the ultra-virus claim is validly asserted, and there's enough evidence to support it.
So what happened to the property?
Excuse me, Your Honor?
What happened to the property? If they're seized by the city, and what did you determine to effectively, what was the result of the property? Where is it? Is it in storage? Was it
The city
burned?
maintains some of that property. I think the record states that some of the property was returned. The city maintains some of the, I'm assuming, the machines and the motherboards, and then the cash as well. And so
Even after the warrant was suppressed?
after the warrant was suppressed, after the charges were filed, despite the fact that no forfeiture proceedings were initiated, or the record does not show that the state initiated forfeiture proceedings, as was their obligation under the criminal code to do so.
Now, you had to plead that the property was taken for public use. I don't know that I saw a pleading for that. What was the public use? And then if you would please respond to Ms. Stroh's comment that property seized pursuant to a warrant is not for public use.
Yes, Your Honor. In our motions for summary judgment, we did respond with evidence that the property that was seized and the funds that were seized went directly to fund police activity, and that is in the form of the ordinance and the affidavits that were provided, the agreement between the city and the sheriff's office.
Is that the evidence you're referring to?
That is the
agreement?
That is the evidence. There's also evidence that the property was never returned, and the officers admitted that they still have possession of the property.
But what is the evidence that it was sold and funds were used?
That evidence, I will have to look in the record, but the cash that was seized, although we don't know where it went, it's with the city still. It has not been returned, despite the fact that all these charges were dismissed and that there was no illegal activity occurring here, according to the criminal court that already adjudicated this conduct that was happening.
So there's no evidence that you can point to right now that shows that there was the agreement in place, and in this particular case, those monies went to public use.
There is no evidence that I would be happy to file a supplemental brief to point the court to that evidence, and I would be happy to do that.
Please do.
And as to your second question, Your Honor, about Justice Rios, about the public use aspect, Steele versus City of Houston is a case that is very on point here. And in that case, the City of Houston, police officers raided a home where they believed fugitives were hiding out. In that case, the homeowners brought a takings claim against the city for the destruction of their property, and the Supreme Court upheld that takings claim was a viable takings claim. And they said that the pursuit of public safety, in that case, the officers were acting to dissipate an emergency that was a threat to the public. That was for public use. The Supreme Court said that that could show public use in that aspect. And here we have more than the officers acting under the authority of their uniform. We know that according to these ordinances and these agreements, any funds seized from these raids go to the police officers' fund. We have that evidence in the record. And so that shows direct public use.
Let's talk about the first element as well of the takings. It's a governmental entity intentionally performs a certain act in the exercise of its lawful authority. So these detectives were acting pursuant to warrants. So how is that, okay, so that, you're saying that's lawful?
Yes.
Okay.
I'm saying that's lawful and that's intentional, but even a lawful exercise of police power does not immunize the city from a takings claim, and that is been upheld by the Supreme Court over and over. For example, in Texas Department of Transportation versus Self, TxDOT cut down trees outside of an easement that they owned. And the Supreme Court held that the plaintiffs in that case had alleged a viable takings claim, despite the fact that the officers or the government employees there did not know that the property was outside the easement. The intent to cut the trees down was the taking. And here, the intent to seize the property, seize the cash, destroy the machines, is the taking.
So, and you said it's lawful because it's pursuant to a search warrant, but in your prayer, in your petition under E, you have the defendants have taken plaintiff's property without just compensation through wrongful seizures. Is wrongful the equivalent of unlawful? And thus, you don't meet that first element in the takings.
I don't believe so, Your Honor. Wrongful just means that, under the law, there was no authority to seize these machines because they were not illegal to begin with. And the officers knew that the machines themselves fit within this exclusion. So I don't think that that declaration would bar us from that relief. And declaring that they did not receive adequate compensation would be appropriate because they did not receive compensation for the destruction of their machines or for any of the other property that was seized.
So I have a quick question, just sort of a follow-up to the question Justice Rios asked before. When you have a takings claim, and we've already discussed it, it's with you're saying lawful authority, right? So these officers were acting with lawful authority. Your ultra-virus claim is saying they're acting outside their authority. So clearly those appear inherently contradictory.
I don't think that they are. Under a takings claim, the intent to take is what is lawful, grants lawful authority. So these officers acting pursuant to a search warrant are acting lawfully for the purposes of a takings claim in that they've been given this authority to seize these machines and they're acting pursuant to that. In an ultra-virus claim, it speaks to the officers the scope of their authority and whether they're acting outside of it. And so their interpretation or their disregard for this penal statute, that it goes to that. So I don't think that the two would cancel each other out. I think the intent required to meet the elements under both is different. And so, Your Honor, to clarify, the first point that opposing counsel made regarding the declaratory and injunctive relief, if, as opposing counsel stated, the two claims that are at issue before the court today is the takings claim against the city and the ultra-virus claims against the officers. If appellees have alleged a viable takings claim, which they have, then they're entitled to compensatory relief and they would be entitled to declaratory relief. If they've alleged a viable ultra-virus claim, which they have, they would be entitled to injunctive relief. And so the city does not have immunity from those claims if appellees have alleged a viable takings claim and a viable ultra-virus claim.
Has the property been returned? Got an order to return the seized property.
Some of the property has been returned. It's not clear from the record what has been returned, what has not been returned. What was appellee's burden to show at the summary judgment stage was that there was some property that had not been returned, and there's evidence of that in the record. The city also admits that in their briefing.
Are you essentially saying that there's whatever burden a movement had at summary judgment wasn't, as a matter of law, met? So there's a bunch of facts still out there that prevent summary judgment at this place?
And there are absolutely disputed facts, and that would prevent summary judgment in this case. For example, regarding whether or not what happened to the machines, and my understanding is that there is discovery still outstanding in the trial court regarding that. Regarding opposing counsel's...
Respondent counsel or the appellant and her arguments that Garcia is dispositive.
Garcia is not dispositive here. In that case, the taking that Garcia was challenging was the destruction of some coffee grounds that were in his car that the officers put their finger into as they were searching his vehicle. That was in the scope of their investigation. That was pursuant to the automobile exception. There were many distinguishing factors there. And in that case, he was convicted. He also raised other challenges under constitutional law that are not relevant here. But the case here is easily distinguishable because these officers sought these warrants despite knowing that these machines were within the legal exception. They seized these machines despite knowing that a court had found that they were legally operated or that they were within this legal exception. And they also seized money from Mr. Martin's businesses despite knowing that he was operating them legally and in compliance with state law and with city law.
What was the evidence that the detectives or the officers knew that these were being operated legally or they were within the legal exclusion?
So in the
Can
record,
I follow up with that more
Yes.
specifically? What did they present to go get the warrant?
Your Honor, Justice Rios, in the record, all three officers testified that at the March 2020 raid, Mr. Martin was present at the raid, and he approached Detective Castano and maybe Detective Moynihan to let them know that the criminal court had been dismissing these cases, that the court had found that the machines were within the exception under the penal code, and that he had been operating them legally. He even gave them a case number to put them on notice of the fact that a criminal court had adjudicated that this conduct was legal. And so that is the evidence in the record that the officers knew that the machines were legally operated. And Your Honor, as to your second point, I would have to look at the search warrant to determine, but my understanding from the warrant is that the officers presented a narrative where an undercover would go to whatever business, play a game, and then, recount how much they made in winnings. All of those not all the warrants, but all the charges that arose from pursuant to those warrants were dismissed. Certain warrants were also suppressed. And I believe
Can you go into that with us just for a moment? So you're saying, and I just want to make sure I'm understanding correctly. So I think there's 10 raids maybe in this period of time. And so Mr. Martin tells the officers that on at least one occasion, right, and that would be Ms. Gonzalez's case, the judge found there was no probable cause. Judge Vidal says that. How many others have this exact same scenario, this fact pattern? And so let's start there, because I want to make sure I understand when he's saying, these are all being dismissed. He makes that assertion. What is he talking about at that time when he's telling the officers this?
At the time, he's telling the officers that the 4 previous raids in which they have arrested the patrons that come to his business, in which they've seized the machines, and in which they've charged his business partner, they've all been dismissed, and a warrant that authorized them to seize those machines was suppressed, and that the court has found that the machines are legal. That's in March of 2020. After that, the officers raid him another 6 times. And the fact pattern, to my understanding, is the same across the board. They raid not only Mr. Martin's businesses, but they raid the same businesses over and over again, and the same businesses that they raided pursuant to the warrant that was suppressed, they raided again after. Those businesses had the same machines, they were also licensed, they were registered with the city, and they operated in the same way.
Under different warrants?
Under different warrants.
Somebody's out there just getting warrants from the same judge, different judge?
Different judges, they would approach whatever magistrate, I'm assuming, was on the bench.
And they were all suppressed?
They were all suppressed.
Because according to
I'm not sure that they were all
Judge
suppressed.
Barra did was basically that these silver trinkets never amounted to a value that exceeded the, let's just say, $20 that they gave, and they couldn't be exchanged effectively like currency in any other establishment, and what they just, it's all outlined in the findings of fact.
Yes, it is in the findings of fact, and there were many reasons why the machines did not fall within, the many reasons why the machines were not gambling paraphernalia.
But you're not challenging the constitutionality again. And if you are, then we go back to Sterling. And then opposing counsel says Sterling's dispositive.
Sterling is not dispositive. Sterling is very distinct in the fact that Sterling at the time when The suit was filed by Sterling to enjoin the police department. A criminal suit was filed after, so prosecution was still pending, and asking the court to enjoin the officers from further investigating and seizing the machines would obviously interfere with that prosecution. That concern does not exist here. These prosecutions have long ended. They have been totally unsuccessful, and that is the key distinction. This is a property rights case. The criminal courts have already found that Mr. Martin has been operating these machines within the confines of the law. He has taken great measures to ensure that his machines are operated legally. And despite that, the city has been seizing and destroying his machines and taking other property at his businesses. And in regards to counsel's argument regarding the constitutionality of the statute, we don't think that this court should reach that issue in this proceeding because it is not ripe for this court's consideration. City of Fort Worth versus Riley, that case is distinct because summary judgment was granted in that case, and there was no issue about whether or not the penal code applied. Here, the city won't even agree that the penal code applies in the first place, and there are facts outstanding for the trial court or a fact finder to determine whether or not the machines even fall within this exclusion. And so that issue is not properly before this court. And quickly, to respond to counsel's argument on jurisdiction, even appealing under 51.014A8, which allows the governmental body to appeal a plea to the jurisdiction, the scope of that appeal is still narrower than the issues that are presented in this appeal. For example, the issues about whether or not any issues that pertain to the city's liability in this case, with the contrast to their immunity, are not properly before this court. Under the city's position that they are advocating for, a governmental body can come in, destroy a person's lawfully held property, go to court, lose in criminal court, never move for forfeiture, and then stay immune as a matter of law from judicial review. That cannot be the law. This court should affirm.
Thank you, counsel.
Mr. would you, before you start,
Okay.
would you address her last point, that the scope of that 51.014A8 narrows the scope in this case?
No. And in fact, for a plea that I'm going to get into more explanation, but I'll just start out with the standard of review for a plea to the jurisdiction. There is a specific standard of review for a plea to the jurisdiction when immunity and the merits are intertwined. If you could never have a discussion of the merits in the context of immunity, you wouldn't need a special standard of review that mirrors summary judgment. But of course, the merits are discussed in the context of immunity all the time. For example, the Supreme Court has said the court has jurisdiction over an interlocutory appeal discussing the merits of a takings claim, because there is no waiver of immunity unless the takings claim is viable. Under the Texas Labor Code, we talk about the merits seriously, whether there's discrimination, every aspect of the merits in terms of immunity. And this court, I've had appeals before this court that have been transferred to the El Paso Court of Appeals discussing exactly that, a merits determination under the Texas Labor Code. Under section 101.021, waiver is, immunity is waived under the Texas tort claim only to the extent the city could be held liable as a private person. So for example, if a private person couldn't be held liable because a plaintiff has actual notice of a condition, which is a merits issue, there's no waiver of immunity. So it's simply improper and not in accordance with the law to say that if an immunity issue discusses merits, that it's not an immunity issue and not subject to interlocutory appeal. I want to make this one point really quickly before it slips away. The findings of fact and conclusions of law are not in evidence. They were excluded by the trial court. They are Exhibit 14 in the trial court's order on summary judgment. Exhibit 14 was excluded. We expressly objected to the signed findings of fact and conclusions of law by the court. But I don't know what they have to do with anything. I don't know what they have to do with public use. I don't know what they have to do with ultravirus. She didn't discuss Houston Terminal, but I'm going to discuss Hall. It's cited in our brief. And the court should really take a look at it in terms of thinking about what their ultravirus claim is. The Hall is a decision by the Supreme Court of Texas where the Supreme Court made a distinction between the enabling statute, and a collateral law. And you only get an ultra-virus claim if you act outside of the enabling statute. You do not get an ultra-virus claim if you misinterpret a collateral law. Section 47.014B 014B is a collateral penal statute. The Supreme Court of Texas has said the enabling law is in Article 2.13 of the Texas Code of Criminal Procedure, now codified at Article 2A.051, I believe it is. Gives the officers authority to execute search warrants, to apply for search warrants, to keep the peace, etc., to interpret penal law, as did the delegation of authority by the board in Hall to a UT chancellor to interpret federal and state privacy law. The Supreme Court still held that that federal privacy law that he interpreted, supposedly erroneously, was a collateral statute and could not form the basis of a claim for ultravirus. So what the findings of fact and conclusions of law, which aren't even in evidence, they never argued any reason why the trial court erred in their briefing. What that has to do with anything, showing public use, showing ultravirus, is a mystery to me. But I do want to correct the record so the court's not left with any misimpression. That findings of fact and conclusions of law said that 47.014B was not violated because they couldn't exchange the silver for cash at the establishment. There's no case law saying that that's a requirement for something to be a cash equivalent. Hardy says easily exchangeable for cash, not at the very location, but easily exchangeable for cash and having a readily marketable value. That's it. Moreover, it's not accurate to say that all of these proceedings were dismissed for because all of the judges believed that the appellee's interpretation of 47.014B is correct. They were dismissed. If you look at their Exhibit 13, they were dismissed for a number of reasons. Failure to comply with the speedy trial rule, missing witness, further investigation, in the interest of justice, conditionally dismissed based on a forfeiture of all of the gambling things that were seized, machines, cash, etc. A handful were dismissed for insufficient evidence, but there's no further information on those. And if you look at our exhibits, O and N, the very first raid resulted in an order in which the defendant agreed that he violated Section 40, I'm going to mess up now, I've said it so many times, 47.014B, that he violated it. Even if the court wanted to look and say, well, we're going to consider whether, there was a good faith basis to interpret this as an ultravirus claim, there clearly was. They had 2 Texas Attorney General opinions saying it's unconstitutional. They had the very first raid resulted in an admission by the defendant that what he did was unlawful. So there's more than enough to support an ultravirus claim, but you don't look to the collateral law anyway. You only look to the enabling statute. They don't talk about the enabling statute at all.
How do you respond to what counsel shared, what was otherwise also in the record to controvert any contention about the law enforcement's actions?
What about the law enforcement's actions?
Whether or not they were just dutifully following doing their job and executing an authorized warrant, that there was more to it than that. And the record does reflect that there is a lot of activity conducted by law enforcement, particularly on this particular property owner, that prevents a court, like the trial court, from saying that it was just an official duty performed that might have been the result of a misinterpretation of their authority. That there's a little bit more to that. How would you respond
Well, their only claim for ultra-virus is that they acted outside of their lawful authority. The only lawful authority you look to
Do they
is,
have to do more? I mean, that's all they have to do, is they have to raise a fact issue at a summary judgment to show the trier of fact that, in fact, there is an issue of fact still about whether or not they were, in fact, in the execution of their authorized duties, misinterpreting the law or doing something else.
it's not, misinterpreting a law is not enough because it's the collateral law, not the enabling law, so that will never get them where they need to be for ultra-virus. And in terms of doing something else, the only other ground for an ultra-virus claim is failing to perform a ministerial duty, and they made no claim about that. There's nothing that they did that were outside the warrants. The warrants are in the record. Their affidavits for the warrants are in the record. Their affidavits in support of the summary judgment are in the record.
I understand this position of the city.
Yeah.
What I'm asking you to respond to is about the controverting evidence that was submitted that tends to make that presumption, that position not as strong, let's just say.
There's no controverting evidence that would raise any fact issue on any
You
issue.
simply just disagree. I'm just asking her to see if you can respond to what that evidence is in the record, as pointed out by the appellees.
Well, I guess the only evidence they're referring to are the findings of fact and conclusions of law that were excluded from evidence. So there is no evidence in the record. Those findings of fact and conclusions of law were expressly excluded by the trial court. So I'm not sure.
Was the warrant suppressed?
There was a warrant suppressed in that exhibit, but that exhibit was excluded from evidence.
Was the warrant in this case suppressed?
Well, there were multiple warrants.
They were all suppressed?
I'm sorry?
Were they all suppressed?
No. If you look at Exhibit 13, which concerns the dismissal of the various cases, again, has nothing to do with ultravirus and whether they meet ultravirus, nothing to do with public use. But if you look at Exhibit 13, the cases were dismissed for a number of reasons. Like I said, failure to comply with speedy trial, interest of justice, whatever that means, conditional dismissal for agreeing to turn over everything that was seized and not try and recoup it. Those kinds of dismissals. There were a few that referenced insufficient evidence with the box checked. There's a slash there on some of them that says suppression granted, but you don't know which is which. So, and it doesn't explain why the trial court thought there was insufficient evidence.
And your position is that none of that precludes, as a matter of law, the entry of summary judgment?
None of it, because it concerns interpretation of a collateral law and not the enabling statute.
Yeah, opposing counsel mentioned with regard to the takings claim, and I referred her to her petition and the prayer, and I think it's her position that the seizures were wrongful, but they're not unlawful. So, and I should have followed up with the question then, is it tortious? Because if it's tortious, then there is immunity still stands with regard to a takings claim. Do you agree, or can you expound on that?
That's right. And in fact, that's an argument that we made in our brief, that their petition actually does claim that it's unlawful because the entirety of their claims, not just the declaratory and injunctive relief claims, not just ultravirus, but their takings claim too, relies on their interpretation of Section 47014B to assert that the officers never should have executed these search warrants in the first place because they weren't violating the law. So that what the officers did was go and investigate lawful activity, serve search warrants, conduct searches, make seizures of property when the statute didn't permit them to do that. So yes, their entire crux of their case is saying that what we did was unlawful. Even though they admit the search warrants are valid and they're not contesting the validity and that we acted within the scope of them, that's the entire crux of their case. But the court doesn't even need to go there. I mean, we've offered 4 separate bases for why their takings claim doesn't survive. That would be a 5th.
Thank you.
Thank you.
Your case will be submitted, and an opinion forthcoming. This matter is adjourned.
All rise.